The difference between a trust and an estate really relates to the document that controls the asset when someone dies. The estate generally refers to what is called the probate estate, the assets that are passing under the will. These are assets that are owned by the deceased individual in their name alone versus other assets that are owned jointly or in trust. Trust-owned assets, that's where we're dealing with the trust administration. Assets that are owned by the trust itself as an entity and are controlled by the terms of the trust contract. What should be included in a trust from an asset standpoint? The general rule is everything, but of course with any general rule there are exceptions. You should not put retirement accounts into a trust, maybe name a trust as beneficiary in some circumstances, not every. You should maybe name a trust as beneficiary of life insurance or annuity contracts and not have the trust owned by those in many instances. Automobiles generally should not be in a trust. Maybe your day-to-day checking account should not be in a trust, but generally everything else you want to consider putting into a revocable trust. Things like your real estate, non-retirement investment accounts, savings bonds, savings accounts, CDs, money market accounts. Those kinds of assets you generally want to put into the trust. Estate and trust administration is one of those areas where it is so important to seek the assistance of counsel before you do anything. During an initial consultation for an estate and trust settlement matter, we will generally go through a 5-step process of inventorying, appraising, retitling, taxation, and distribution of the assets. We'll familiarize the client with that 5-step process, with the timeline that they should expect for getting through the process, and some of the costs that are associated with that. What might be the tax expectations? Is there going to be an estate tax? And how we can help them through that process.